Welcome to Behind the Robe, the podcast that explores legal tools which add value to your life or business. Now here is your host, Joe Dragon.
Hello, and welcome to another episode of Behind the Robe. Today we're going to be talking about estate planning and some of the estate basics to get your estate in order. If you're watching this video or reading the articles posted to dragonlawgroup.com, then you are doing so because you want to know some things about estate planning. And I assume that either you haven't done any sort of estate planning or you have done something like a will some time ago and you need to update it. Whether you decide to do your estate plan on your own, it's not advisable for most estates, but if it's small enough, it probably can be done, or seek the assistance of an attorney. One of the key parts of estate planning on your end is to have a general knowledge of what it is and what you can do with it. This is going to help you in a lot of respects. One, if you know generally the tools of estate planning, whether it be a will or a trust, you will have a better idea of how to obtain the goals that you want with your estate planning. Two, once you obtain those goals, it's going to be much easier for you to communicate those goals with your attorney, and that'll save you time and money. Okay, so what is it that you need to know about estate planning? The first thing I would say is to start by knowing what would happen if you don't have an estate plan in place at the time of your death. In that scenario, the state of Nevada will default to its laws of intestacy. Intestacy means dying without a will or a trust in place. So by knowing what would happen if you don't have an estate plan, you get a general idea of the types of things you want to change with your estate plan. Okay, so whether you pass away without a will in an estate or with a will, what's going to happen is that your estate will have to be submitted to probate. Now, most of us know what probate is. For those of us that have a looser grasp, probate is the process of the court dividing up your assets and your money and distributing it to the people or entities that you either named in your will, or the court will follow Nevada law on intestacy rules. In other words, those laws will direct the court what to do with your assets. Okay, that's the intestacy part. Keep in mind that Nevada is not going to automatically submit your estate to probate. Okay, so I think a lot of people don't quite grasp this concept as much, but the reason you need a probate process is that the assets are in your name on the time of your death. Obviously, you can't use them anymore. So the people who might have an interest in using them need to get those assets transferred in their name. Okay, that could be your house, car, or it's just your money in your bank account. Somebody needs to have legal ownership of that. So interested parties would be your creditors. If you have any creditors, you no longer have the ability to make payments. Therefore, they need the court to order those payments be made. Other interested parties, of course, who gets the assets. Now, if you had a will, you would name the people who got the assets. Without a will, the court has to make its best guess on how you would have wanted those assets distributed had you made one. Now, the court itself does not make this guess. Okay, that is Nevada law, and Nevada law dictates to the court how it shall divvy up the assets. So basically, the Nevada legislature, when they wrote that law, is the entity that made the best guess on how your assets distributed. Now, in reality, whether you die in Nevada or whether someone passes away in a different state, the rules are pretty similar throughout the country. And for the most part, one state just copies the rules of the state on intestacy that came before it. It may make some modifications. Every state has some modifications. Big idea still remains. Okay, so logical step in figuring out this process is who if you were the Nevada legislature, how would you guess on how a stranger would want their assets divided? Now, a first kind of reaction to that would be probably let your loved ones decide, since they were close to the problems that state law, Northern Nevada courts will allow this. And basically what I'm saying is they will not allow, for the most part, your loved ones or friends and testify before the probate court on how they think that you would want your assets divided. Even if they say, look, my friend Sam passed away. He told me that I was supposed to get his car, or that my sister was supposed to get his car, or what have you. And the reason for that is actually quite obvious, because it becomes a mess really quick, right? Generally, we want to believe in the good nature of people, but the reality is that most people feel they're entitled to something, whether it be the decedent's kids or spouse or parents, and probably have a different conception on how the decedent they think should pass the estate versus interested parties' interests. So instead of doing that, the second, kind of natural reaction on how to administer an estate would be to give it automatically to certain heirs that survive you. For instance, if you passed away with children, right, a good guess would be that you want most of your money to go to your children. Or if you passed away with a spouse, then a majority of your money would go to your spouse. Generally, if you're making a guess on how people would want their assets distributed, that's a pretty safe guess. So that is what intestacy actually does. Okay, so the first thing that would happen if you passed away without a will is that an interested party would have to petition the court to probate. Usually a family member that would have an interest in your assets via the intestate laws, or a creditor who needs to get paid. But someone has to petition the court, otherwise those assets are frozen. After the matter is petitioned for a probate, the next job is to figure out, what heirs are alive. You have to give notice, for instance, to any and all people who may have an interest in the estate. Perhaps the decedent didn't have any children, so in that instance, it might go to the his or her parents if they're still alive. But then if they're not alive, then it would go to their siblings, and you get kind of further and further down the path in determining how the assets should be distributed. Now, I'm not going to get very deep into that. I'll hit some highlights on that because it's actually a law school final exam, and it bored me then. I'm sure it'll bore you now. But for the common scenarios, okay, if you pass away without a estate plan in place, and if you're married and your spouse survives you, then at least 50% is supposed to go to your spouse. If you are survived by your spouse and at least one living child, then 50% would be divided up between the two of them. If you have more than one surviving child, then and a surviving spouse, then 1/3 to the surviving spouse, and the remaining third will be divided equally amongst the living children. If you don't have any children or a spouse alive, then you start getting into those extra layers of complicity, and all this needs to be figured out via the probate process. Okay, if you want to know more about the details of that, you can look up on the article that I posted at Dragon Law Group with a link to Nevada law. Not sure why you'd want to do that in case you're looking for some reason to fall asleep, but it's there. Okay, so basically the highlight was, if you are survived by a spouse or living children, the takeaway is that the majority of your assets will be divided between them, and with the heavier weight for the spouse. Now, something very important to understand here, because that's not really in practice what happens. Let me tell you why. Although Nevada has those interstate laws, Nevada is also called what's a community property state. And it's the same thing in California, Oregon, Washington, and a lot of other Western states. Community property is a term that applies to married couples. Okay. Most of us have heard the term. Most of us have a general understanding of what it is. But again, let me just lay it out for you. So if you get married, provided it's not a prenuptial agreement, from the date that you're married to either your divorce or one of the spouse's death, all property, meaning money, income, cars, houses, anything and everything that could have some sort of value that is obtained during that time, okay, from the date of marriage until the marriage ends, is shared by both spouses. And the law calls this equally and jointly, meaning both spouses have an equal right to all the assets and and one spouse can do whatever he or she wants with that money. Okay, so for instance, if two spouses were making $500,000 a year, and one spouse makes 190,000, and the other makes the difference, which would be 390,000, and the spouse that made more money, it's not his or her money, it's the community's money. Therefore, the other spouse who made less, that she doesn't need or he doesn't need consent to spend that money. Okay, it doesn't need a legal, gift or power of attorney to spend that money. And generally, we know that. Another very important characteristic of community property law is that this community property has right to survivorship, meaning that this first spouse to pass away, the community property, assuming that their children are age of majority, passes to the other spouse 100%. Okay, not by an operation of a probate process, but by operation of the community property law, if that makes sense. So, in other words, as I said before, if somebody passes away without a spouse, the children do not, and has children, that child does not have ownership of that property until the probate court says they do. Not so with a spouse. A spouse already has ownership with that. So as I said before, under the intestacy laws of Nevada, half of a deceased spouse money is supposed to go to the living spouse, right? And half of it's supposed to go to the living child. But that does not happen for community property, okay? So for instance, if a marriage was 40 years long and the parties got married at a young age and really didn't have any money before they got married, well, there's nothing left to pass to the child because it's all community property. Okay, that makes sense too, because it wouldn't make too much sense to automatically give half of an estate to a child when you're talking about a marriage. The property that would be technically 50% would go to a single living child would be what's called separate property. Okay, and that's just the inverse of community property. If you're not married, you technically all your property is separate property because you don't have a spouse to share it with. So you wouldn't use that term. It comes into divorce and probate. And the separate property is property that a spouse obtained. There are some exceptions, but usually before the marriage began. So if you had, a $200,000 watch, let's just say, I don't know, expensive watch, but just say you did that you owned before you were married, well, then that's separate property. Okay, so that would be sold and distributed. 50% would go to your living spouse of the proceeds, so 100,000, and the other 100,000 would go to the children then living. But in reality, there's not a lot of separate property that ever gets divided. Usually it's because marriages aren't, typically long, or usually are typically long. And the only way you can have separate properties, you'd have to trace it back before the marriage. The watch was a good example because you can easily do that. But usually what happens is you might have a certain amount of thousands of dollars and the spouse may have a certain amount of $1,000 when they get married. After they get married, all that money gets commingled into kind of, they're both using it. And so it'd be impossible to trace back. So reality, most of decedent's property, if they're married, will be community property. Now, that's not typically a problem, it can be a problem, just depending on the relationship. But for couples that are happily married and, they have the same children, most of us would say, yes, if I die, I want my spouse to have the estate, full control of the estate, not my children. But it can become a much more of a problem when you're talking about either mostly arises when you may have had a divorce, you get remarried, and you had children from the previous marriage. Okay, and depending on, and it get a little complex here, but depending on the how long the second marriage in, probably most of that money will be community property. Okay, and there's a difference here because you may not, maybe your children were older when you got remarried, and although you want a significant portion to go to your then spouse, maybe you think it's not realistic that your new spouse and his or her stepchildren will have a strong relationship or something like that. Basically, the new spouse takes all the cedent's money and doesn't really leave anything for the children from the previous marriage. That's one example of a kind of a problem like that. They come up in lots of different scenarios, but just keep in mind that can be a big problem as far as the surviving spouse issue. Okay, so that is basically intestacy kind of broken down as far as what happens without drafting a will or creating a trust. It's not exactly super exciting information. This is the stuff that we think about all the time. But by knowing this, you will have a building block to kind of figure out how to change these default intestacy rules with estate planning. And from there, you can start to craft ways to improve it. Basically, take matters into your own hand. And that's what some of the subsequent podcasts are going to get into. And the next podcast and article you should look at is difference between a will and a trust. Okay. And the will and the trust are two tools you can use to make effective estate planning. So thank you for listening to this podcast. If you have any questions, you can feel free to, my email is jdragon@dragonlawgroup.com. Feel free to send me an email, or you can get a hold of my contact information at dragonlawgroup.com. You can find a link to this video and podcast, as well as our contact information. Thank you very much.
Thank you for listening to Behind the Robe. If you have any questions related to this or similar topics, please feel free to send Dragon Law Group an email to jdragon@dragonlawgroup.com or visit dragonlawgroup.com. Please subscribe to Behind the Robe for future podcasts covering legal topics that can improve your life and business.